Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineered. Good day to all the students and viewers here in my YouTube channel, Legally Engineered. Again, I am attorney Engineer Bendrick Imaradit, and I am here to discuss to you the form, reformation, and interpretation of contracts. Now that you've been done learning about what a contract is, it's important for you to know as students that there will be instances wherein you will encounter doubtful and conflicting provisions of a contract. And whenever the contracting parties, for instance, would have these disputes, the question is, how are you going to interpret the contract and how are you going to harmonize it? And we will be learning that towards the end of our discussion. But before we proceed to interpretation of the contracts, we would have to discuss first the form and reformation of contracts. Form of contracts that is covered by Article 1356 to Article 1358 of the New Civil Code, and reformation of instruments, which is covered by Article 1359 to Article 1369 of the New Civil Code. Alright, so let's dive in right away to the first article that we would have to discuss when it comes to the form of the contracts, and that is Article 1356 of the Civil Code, which provides that contracts shall be obligatory in whatever form they may have been entered into, provided that all of the essential requisites for their validity are present. So this would be the general rule. So whatever the forms that of contract, the manner that it is entered into by the contracting parties, the general rule is that it would be valid and binding for as long as all the essential requisites, cause, object, and consideration are present. However, when the law requires that a contract must be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such case, the right of the parties stated in the following article cannot be exercised. So that would be an exception to the general rule that in this case, kapag ang batas ay nag-lay down ng provisions or ng requirements for the validity and enforceability of the contract, then the same is an indispensable requirement and the same must be complied with accordingly. Now, what is the form of contracts, or ano bang meaning nito? The form of a contract refers to the manner in which a contract is executed or manifested. So, paano ba pinapasok yung kontrata? Paano ba in-execute yung kontrata? That would be the topics covered by the form of a contract. And the contract actually may be in oral, no? Maybe oral contract, a written contract, or in writing, or partly oral and partly writing. It may actually be expressed when the parties would expressly stipulate their intentions, or it could also be implied when their intentions may be inferred from their actions or conduct, kasi hindi naman lahat ay in writing. So it can also be inferred dun sa actuations nga ng parties. If it's in writing, then it may be in a public instrument or a private instrument, and we will define and discuss that a little later in our lecture. Now, when contract considered in written form, kailan ba nakukonsider na ang contract is in written form? Well, it is generally recognized to be a written contract if all of its items are in writing. So, written contract siya kapag lahat na nga ng items or provisions ng kontrata ay nasusulat. So, a contract, partly in writing and partly oral, is in legal effect an oral contract. So, if it's a mixture of an oral contract and some of the provisions are in writing, then the Supreme Court has held in the jurisprudence, for example, in the case of Manuel versus Rodriguez, that the same shall be considered as an oral contract. Now, what would be the classifications of contracts according to form? Well, according to the form or method used in creating the contract, they are first, informal or common or simple contract, and then second, formal or solemn contract. So let's go to the first, informal or common or simple contract. These are the contracts which may be entered into in whatever form provided that all the essential requisites for their validity are present. And yun yung dinedefine ng Article 1356. This refers only, however, to consensual contracts, ang Article 1356. Remember, consensual contracts are contracts that are perfected by mere consent, but not all contracts are consensual contracts because there are also real contracts and solemn contracts. So as far as real contracts and solemn contracts are concerned, Article 1356 is not on point in that case. For example, in a contract of sale is a consensual contract. So an informal contract may be oral or written, and in fact may even be implied from the conduct of the parties. And let's go to the second classification, and that is formal or solemn contract, or that which is required by law for its efficacy to be in a certain specified form. So ito yung mga nare-require naman ng batas na dapat in a special form para sa efficacy nito and even for convenience of the parties. Now, what would be the rule regarding the form of contracts? Of course, the general rule is that contracts are binding and therefore enforceable reciprocally by the contracting parties, whatever may be the form in which the contract has been entered into, provided that all the three essential requisites, consent, object, and cause for their validity are present. So a contract may be oral or written. A written contract may consist of a letter, memorandum, note, or other instrument without following any particular form or language, it being sufficient that the parties clearly express their intention. So the goal actually of the law is to respect the stipulations of the parties and in the manner the contracts are entered into by the parties. Kaya nga, yun ang general rule. The contracts are binding and enforceable to the parties in whatever form they might have been entered into, provided that, again, all the three essential requisites of a contract for their validity are present. But yun nga lang, nagbibigay ang batas ng strict provision for special forms for certain contracts, and we will be tackling them one by one a little later. So for example, si buyer left a note in the store of the seller S offering 1,000 pesos to buy the table and display of seller S. If seller S in return called the buyer, maybe through phone, that he's accepting the offer of the buyer for the amount of 1,000 pesos in exchange of the chair, and with the promise that the buyer would pay the same a day after, then in that case, the same contract of sale is valid and binding in that case. And so again, the note and the oral acceptance constitute a legally enforceable contract, and both B, the buyer, and S, the seller, are fully bound by it. Okay, so no specific special forms in that case. A contract of sale being a consensual contract covered by Article 1356 of the Civil Code. Now, that's the general rule, and there are exceptions. And the form, however, is required in following cases. First, when the law requires that a contract be in some form to be valid. So, ito na yung kapag nagre-require na si batas ng specific requirements para maging valid daw yung kontrata. Second is when the law requires that a contract be in some form to be enforceable or proved in a certain way. So, ito naman, kung kanina validity ang pinag-uusapan, ngayon, enforceability or yung proving it in a certain way. So, may nire-require pa rin ng batas for the contract to be in a special form. And then lastly, when the law requires that a contract be in some form for the convenience of the parties or for the purpose of affecting third persons. So, isa-isahin natin to. Dun sa una, form for validity of contract. Para daw sa validity ng contract. Halimbawa, first is donation of real property. Donation of real property, according to Article 749 of the Civil Code, it must be in a public instrument. So, expressly provided yun doon that the donation must be in a public instrument. Otherwise, the deed of donation or the contract would be void. Secondly, if it's donation of personal property, the value of which exceeds 5,000 pesos, then the donation and acceptance must be in writing. That's according to Article 748 of the Civil Code. Pag i-differentiate muna natin itong first two. Yung una, deed of donation or donation of real property. When we say real property, these are the immovables. Yung immovable property, for example, a parcel of land, no? Magdo-donate ka ng lupa sa isang institution, for example, sa isang school para patayo ng school building, or sa isang charitable institution para tayuan, for example, ng home for the aged, or an orphanage. In that case, such donation of the parcel of land to said institution must be in a public instrument. Yun yung sinasabi ng Article 749. Kasi kapag hindi daw, the donation will be void. Okay. Now, yung sumunod naman is donation of personal property if the value exceeds 5,000 pesos. Kung kanina, ang real property are immovables, ang personal property naman ngayon, these are the movables. For example, pera, no? Donation ng money. If it's exceeding daw yung value ng movable, for example, na i-donate mo, or yung pera na i-donate mo is more than 5,000 pesos, then it should be in writing. Take note na yung kanina, real property, regardless of its price, it must be in a public instrument. Now, movable property or personal property, if it exceeds, the value exceeds 5,000 pesos, it must be in writing. So, hindi sinabing public instrument ha, basta sinabing in writing. So, pwedeng private writing, no? Hindi public instrument. Okay na daw yun, according to Article 748. Yung pangatlo, sale of land through an agent. So, nangyayari to na, for example, the principal would commission people as his agents to find a buyer, for example, sa binibenta niyang lupa. If the same will be done by the principal, then the principal should make sure that the authority being granted to the agent or agents must be in writing. Otherwise, the sale is void according to Article 1874. So, nilarapat lang na kapag magbibigay ka ng authority sa mga agents na ibenta yung lupa mo, it must be in writing. Kasi nga, mag-void daw yan kapag hindi in writing. So, take note of that. For example, special power of attorney, empowering the person to be your agent to sell it. As simple as that. That is sufficient to, kahit na in writing lang, hindi naman sinabing public instrument. So, basta you have to put it in writing para hindi ma-void yung sale in that case. Pang-apat, stipulation to pay interest. Very common to in a contract of loan, kung saan si creditor nagpapahiram ng pera kay debtor. Of course, ang kalakaran dyan is that pag ibinalik, may interest para kumita yung pera. Ang sinasabi lang ng batas, malinaw sa Article 1956 of the Civil Code that it must be expressly stipulated and it must be in writing. Naintindihan nyo naman yan dun sa obligation, diba? Sa discussion of obligation na para makasingil ka ng interest, it must be in writing, stipulated in writing, because otherwise, if it's not in writing, then there will be no interest due. So, tatandaan nyo yan because this is very important, especially nga pagdating sa contract of loans. Contract of partnership. In this case, if, for example, two or more persons would join together to put up a business, for example, and they would contribute, let's say, immovable property as a capital to the partnership, then expressly provided ng batas under Article 1771 and Article 1773 that the contract of partnership must be in a public instrument. And in that public instrument, you will attach the inventory of the immovable, signed inventory of the immovable. You have to attach it doon sa inyong contract of partnership if there is a contribution of immovable property to the contract of partnership. So those are just some of the contracts wherein the law expressly provide a special form for the contract to be valid. So otherwise, pag hindi nag-comply, may question dyan ng validity of the contract itself. Now, form for enforceability of the contract naman. So, in the case of contracts covered by the Statute of Frauds, the law requires that they be in writing subscribed by the party charged or by his agent according to Article 1403, Paragraph 2. So you have to know if the contract you're entering into is covered by the Statute of Frauds. Kasi pag covered ng Statute of Frauds, expressly provided nga that they must be in writing subscribed by the parties of or their agent. If the contract is not in writing, take note that the contract is still valid, assuming all the essential elements are present, ha? But even though if it is valid, it cannot be proved and therefore it cannot be enforced by either party if the other refused to perform the contract unless it is ratified by the latter according to Article 1405. So nililinaw lang nito na yung mga contracts na covered ng Statute of Frauds dapat daw ay in writing. Kasi nga, kung hindi yan in writing, hindi mo ma-prove yung existence niyan, eh paano kung i-deny nung kabilang party or mag-refuse to comply yung other party, then the same is not enforceable kasi you did not put it into writing, and that's gonna be a problem. The only exception is that even though it is not in writing, but if the party or parties would ratify it by their actions or by what they do, no, after the execution of the contract, if the same is ratified, then it would be enforceable pa din, even if it's not in writing. But general rule is that pag covered yan ng statute of fraud, you have to make sure that it is in writing for it to be enforceable. So, unenforceable contracts covered din ng other module, yung discussion on that, but we know that unenforceable contracts are contracts that are actually valid, but they are enforceable unless ratified by the parties. Okay? Now, under Article 1357, provided dyan that if the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. And this right may be exercised simultaneously with the action upon the contract. So, nililinaw lang dito na kung halimbawa nire-require ng batas na yung kontrata must be in a special form or nire-require yung document para dun sa contract na yun, yung contracting parties daw may actually compel each other to observe that form even after the contract has been perfected, no? And of course, may requirement bago mo ma-avail tong 1357 na pag-compel. And before we proceed there, malinaw naman kasi sa atin na in certain cases, a certain form such as putting it in a public instrument is required for the convenience of the parties in order that the contract may be registered in the proper registry to make effective as against third persons the right acquired under such contract. So again, wala namang question if it's between the parties, the contract entered into is legally binding as between them. However, it cannot affect third persons until and unless the same is registered in the proper registry. So in that case, for the convenience of the parties, certain form is prescribed na i-comply for the convenience of parties so that the same can be registered in the proper registry of property. The purpose of which is to bind third persons, including the rights acquired under such contract. Now, pag ba may non-compliance with that required form, would it adversely affect the validity or the enforceability of the contract? Well, the answer is, as between the parties to the contract, it would not affect the validity or enforceability of the same contract. Only as between the parties and third persons, doon tayo medyo magkakaroon ng problema. Kasi again, it's valid and enforceable as between the parties, but it would not be binding to third persons until and unless the special form is complied with. So, and until and unless the same is registered in the registry of property. It is essential before a party may be compelled to execute the required form that the contract be both valid and enforceable. So again, going back to the Article 1357, kung nag-enter kayo ng contract, tapos oral nyo lang ginawa, prescribed ng law is that it must be in writing for it to be, for example, valid, for it to be, kung nire-require ng batas na it must be in writing, then before ma-apply ang 1357, you have to look at first dun sa contract if it's valid and enforceable. Kasi if it's not valid and enforceable, then hindi applicable ang 1357. For example, si R, let's say si R, nag-donate siya ng real property to E, and the donation of the real property is in a private instrument. We know that that donation is void because under Article 749, donation of real property must be in a public instrument. In the example that we are giving, it was only in a private instrument. So we know that again, the donation is void. And since what was required in this case is a public instrument, what they've only done is just a private instrument, then in that case, Article 1357 would not apply because the contract is not valid to begin with. Okay? Now, halimbawa naman, in that contract, sa halip na donation ang nangyari ay contract of sale of a real property, but it is entered into orally. So, question muna ng validity and enforceability of the contract. Well, the contract is valid, but it is unenforceable because the law requires that it should be in writing. Sa example natin, contract of sale of a real property of a land, oral lang yung naging contract nila, we know that it's gonna be unenforceable because we know that it should be in writing for it to be enforceable. So again, in that case, Article 1357 would not apply because even though the contract is valid, it is unenforceable. Exception, if the price has been paid or the property has been delivered, then the contract is valid and enforceable because the Statute of Frauds applies only to executory contracts. So yan naman. So if in the example that I've given, there's a contract of sale of a real property, for example, a land, and the same is entered into orally, we know that the same is valid but unenforceable kasi dapat in writing, right? Pero kung nabayaran na yan, napalipat na yung possession ng property dun sa buyer, then in that case, there is actually in that case executed na yung contract. And kapag executed na yung contract or na-fulfill na ng parties yung obligations and responsibilities incumbent upon them arising from the contract, then in that case, terminated na yung contract na yan and Statute of Frauds will not apply because it is only made applicable to executory contract. So, yung i-execute pa lang ng contract. As example natin, kung nagkabayaran na nga, nilipat na yung possession of the property dun sa buyer, then tapos na yung execution, no? Executed na yan. And Statute of Frauds will no longer apply. Lastly, sa example natin, if the contract of sale is in private writing, then we know that it is valid and binding, although it is still executory, but only as between the parties and not as against third persons without notice until the sale is registered in the Registry of Property. Ito yung sinasabi ko kanina, kung halimbawa nga, nagkaroon ng contract of sale, it is in private writing. Is it valid? Yes, valid. Is it enforceable? Yes, enforceable, but only as between the parties. Until and unless it is made in a, until and unless the same is registered in the Registry of Property, it cannot affect third persons. So, it must be annotated in the Registry of Property to affect third persons. Ito yung naging problema dyan, nagkakaroon ng double sale minsan, kasi hindi naman nga in private writing lang. So, dapat, as much as possible, the same should be registered in the Registry of Property to affect third persons. Kasi yung new buyer, they would only refer to the title kung malinis yung titulo. Now, kung walang annotation dyan, halimbawa, contract of mortgage, kung hindi yan naka-annotate dyan, and then si would-be buyer has all the right in good faith to buy the property. Ang problema nga, paano kung may private contract kayo in private writing, no? So in that case, protektahan ng batas yung new buyer kasi it's negligence on your part not to have registered it in the Registry of Property. So the best, if you would enter into a contract of sale pertaining to an immovable or real property, you have to register it in the Registry of Property. Any affecting any real right for that matter, actually, it has to be registered for it to be valid and binding and enforceable even against a third person. And once it's registered, it's actually binding even against the whole world. Okay? Now, in this case, if for example, CE, the vendee or yung buyer, he has the right to compel R, the vendor, to put the contract in a public instrument so that it can be registered to affect third person. So, ito yung sinasabi natin na doon pa rin sa example natin, nagkaroon ng bentahan ng lupa, it's in a private instrument. Sabi natin valid and enforceable, but it's not valid but it's not enforceable against a third person. So in that case, papatak na applicable ang Article 1357, wherein the parties or the party may compel the other party to execute the contract into the special form prescribed by law. Kasi present naman yung valid, present naman yung enforceable as between the parties. So again, may compelling power under Article 1357. Para nga, for the convenience of the parties, it can be a public instrument and register it in the Registry of Property. Now, the last article for this discussion, the form of contracts, would be under Article 1358. So, if we're going to read the provision under Article 1358, nandyan yung contracts which must appear in a public document. Malinaw na nandyan, dapat nasa public document ang mga contracts na yan. So, balikan natin, ano nga ba muna ang public document? A public document or instrument is one which is acknowledged before a notary public or any authorized official to administer oath. No? Yung mga official authorized to administer oath by the person who executed the same. The party making the acknowledgement formally declares that the instrument is his free and voluntary deed or act, while the officer taking the same attests that and certifies that such party is known to him and that he is the same person who executed the instrument and acknowledge that the instrument is his free act and deed. Any other instrument is considered private. So, as simple as yung mga pinapanotaryuhan nyo, you go to a notary public and let the document or the contract be notarized. So, I am a commissioned notary public. So, when the parties would go to my office and let the contract, for example, of sale or deed of donation or contract of loan be notarized, by doing that, the parties are actually declaring in front of me as a notary public that the same contract is their voluntary deed and act, declaring that provisions na nandun sa contract na yon ay consented talaga nila. And of course, ako as a notary public, when I notarize it, I am attesting that the same persons or parties appeared personally before me in my presence and executed the contract as their free and voluntary act or deed. And once it is notarized or signed by the parties and me as a notary public, then the same is considered as a public document or public instrument. Okay, naintindihan? Any other document na hindi dumaan sa ganung process, kung hindi man sa notary public, dun sa official authorized to administer oath, then the same is considered as a private instrument. The contracts covered by this article, Article 1358, are valid and enforceable. Take note, though not contained in a public document or instrument or in writing. The public document is required only for the convenience and greater protection of the parties and to make the contract binding as against the third person. So, ayan na, para sa greater protection, para maging valid and binding din siya, even as against third persons. In other words, the law does not require accomplishment of certain acts or contracts in a public instrument in order to validate the act or contract, but only to ensure its efficacy so that after the existence of the act or contract has been admitted, the party bound may be ordered by the court in which the action or suit is filed to execute the document. So for example, dyan, sinabi sa 1358, yung acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights. Basta real rights over immovable property, they have to be in a public instrument. Halimbawa, as a security for debt, for his debt, si debtor D mortgage his land to the creditor C. Minortgage na isinangla. This mortgage must appear in a public document. Dapat daw ito ay nasa public document and the same must be, of course, annotated or registered in the Registry of Property to affect third persons. And even the extinguishment of the mortgage upon payment of the debt by D must likewise appear in a public document. So, malinaw na sinasabi doon so that even sales of real property or an interest therein are governed by the Statute of Frauds, Article 1403, Paragraph 2. Second doon sa provision ng under 1358 would be cession or renunciation of hereditary rights or those of conjugal partnership of gains. Halimbawa, si X and Y, magkapatid sila. tatay nila si Z. Si Z subsequently namatay. So we know na kung may mamanahin man, may inheritance ngayon si X and Y from Z. Halimbawa naman si X, he has sufficient property for himself, and X would want to just renounce all his rights over the inheritance and give it all to Y. Then what X must do, or X and Y must do, is to execute an extrajudicial settlement of estate of their father Z, and include therein renunciation or waiver of rights of X. Kailangan i-renounce or i-waive ni X yung rights niya over the inheritance through a public instrument. Okay? Kaya nga, pagdating sa bagay na yan, yung extrajudicial settlement, kung meron mang waiver of rights, ini-include na yun doon. And it has to be notarized and make it as a public instrument. Pangatlo, power to administer property. Halimbawa, si Principal P is leaving for the United States, leaving behind his properties. He may authorize, let's say, A, the agent, to administer his property. And in this case, the authority of A to administer the property of P must appear in a public document. Halimbawa, the special power of attorney, it must be notarized before a notary public. The power to administer properly. And lastly, cession of actions or rights. For example, si debtor, D, mortgage his land to C, the creditor, to secure the payment of a debt. This mortgage appears in a public document. The decision by the creditor of his right as mortgagee to T must also be in a public document. Okay? So, yes. So, those are the 4 instances covered in the Article 1358, and the last paragraph actually in that article provides that all other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one, but sales of goods, chattels, or things in action are governed by Articles 1403, number 2, and 1405. Okay, so take note of that. So there is a threshold amount of 500 pesos. All contracts na ang ini-involve ay exceeding 500 pesos, they must appear in writing down. Even that private one lang, no? Hindi naman kailangan ng public instrument, basta in writing daw siya. Okay, so I hope you've learned from the discussion of form of contracts, and we'll be discussing in another lecture the reformation of contracts and another one for interpretation of contracts. And thank you for tuning in, and please subscribe and share this channel so that you will be hit the notification bell so that you will be notified once there is another upload pertaining to the subsequent modules. And again, this is Attorney Engineer Benedict Marali. Lagi nagsasabi, ignorance of the law excuses no one. This is Legally Engineered.